All right, so good. We're back live, Senate Health and Welfare. And we have with us Craig Fellner, welcome, the Director of Government Affairs from the Infant Nutrition Council of America. Craig, why don't you introduce yourself for the record and let us know a little bit about the Council, Infant Nutrition Council of America, and then offer your testimony. That would be helpful.
Yes, thank you so much, Chairwoman. I appreciate it. I submitted, my name is Craig Fellner. As stated, I'm the Director of Government Affairs for the Infant Nutrition Council of America. We're the trade association for the leading manufacturers of infant formula domestically here in the United States. I submitted my testimony yesterday morning, written testimony, a little bit more lengthy. So hopefully folks have been able to see that and been able to go over that. It offers a lot of commentary on just the issue of heavy metals and what we do to test for it in our industry, and put some of the bill in context as well. Thank you for the opportunity to testify today. Infant formula is the most highly regulated food in the U.S. food supply. Again, infant formula is the most highly regulated food in the food supply. Our industry already tests for heavy metals as part of our longstanding commitment to provide safe, high-quality infant formula products. And as our results show, we test under the strictest of international standards, which are set by the European Union. I thought I would just take a couple minutes and provide a little bit of background, but hopefully will be most helpful on the bill with House consideration. I testified a couple times on the House side. Originally, as you may or may not know, the bill exempted infant formula, and that had been the case in the 4 other states that have adopted baby food programs to test and report. California, Virginia, Illinois, and Maryland. Those are the 4 states that currently have baby food programs. And baby food, just as a reminder too, is regulated, or not regulated, but regulated like any other food in the grocery store, unlike infant formula, which is regulated more like a medicine. So when we were considering it in the House side, I testified a couple times. In a draft, they had taken the infant formula exemption out, and then during the markup, just before the crossover date, they put the exemption back in. And then right before they adjourned, they just decided to do a triggering amendment, as y'all know, which was in the bill that passed on the House floor. I wanted to just take also a couple minutes. I want to leave time for questions, but I did watch the walkthrough that y'all had, and I jotted down a couple questions that I heard from the walkthrough, and I thought I would just sort of generally, talk about them. And then take questions from y'all as well. It was asked, does the European Union have anything like testing and reporting? And my answer to that is no. There are international standards, the strictest set by European Union. The jurisdictions in New Zealand and Australia have heavy metal limits for infant formula just for lead. Canada has one just, I think, either for lead or arsenic. But the European Union is the one that has all 4. But there are no testing and reporting regimes at all in any jurisdictions around the world. And about 2/3 of the world use the European Union standard for infant formula. Somebody asked, what is the bill trying to do that the federal regulations don't do? And I would say, there are currently regulations by the FDA that tell us we have to, as infant formula manufacturers, again, separate from baby food, which is not under any of these regulations. Once our ingredients come into our plants, and our biggest ingredient obviously is dairy, we are mandated to start testing those ingredients for heavy metals when they enter our facilities. And so right away, we are working under FDA guidance and regulations to curb heavy metals. We test along the way. We test final products before they go out. Nothing moves to distribution that is not under the European Union standard. And just real quick before I move to the next question, I think it almost goes without saying, but I feel like I have to say it, and I say it a lot. Obviously, heavy metals are omnipresent, and they're in the water, they're in the air, they're in the animals. Um, there are trace amounts, obviously, in infant formula. There are trace amounts in breast milk. Um, for infant formula, um, though, we have had these controls on us for years, and we test under European Union standards. So that obviously differs from other food items that are in the grocery store. Okay, next question that I jotted down was, what problem were we trying to solve? And I thought this was a great question. As you could probably see if you saw my written testimony, there is no problem with with heavy metals in infant formula. And I would just add that there is a program within the US FDA called Closer to Zero. It's an initiative set by the previous administration that the current administration has adopted and is moving forward to implementation. They're setting standards for baby food and children's food, and then they will get to infant formula very soon. In fact, today, the FDA released a study that is a precursor to setting limits at the federal level. So it was stated actually in 2025, March of 2025, from the FDA that there are trace amounts of heavy metals in infant formula and that there is no health concern with that because they know of the controls that we undertake. Let me just go over one more that I heard. Are the current federal regulations requirements allowing higher levels of cadmium to be out in the market? And the answer obviously is no. There's federal regulations on ingredient testing that we use right when the ingredients enter our plants, and we test for our finished product under EU standards, which are the strictest in the world. And then the last one, somebody commented that you can make a choice about how much cadmium you want to expose your infant to. And I would just say to this one, this is an interesting one. In the picture I'm trying to paint here, in sort of the crux of some of our comments are, if a mom or dad is in a store and they're holding maybe a pouch of baby food or a little jar of baby food, and they're looking at the label, and maybe they're getting anxious about it, or maybe they've hit a QR code that's already in place in a state, for baby food. They can put that jar of baby food down. And they have 150 other choices that they can go grab for their baby or for their older infant or for their younger toddler. They can go buy fruit. They can go buy other items in the grocery store. Putting a label on infant formula, which is the sole source of nutrition for infants other than breast milk, we feel like is going to make a parent anxious. Infant formula is safe. Infant formula is under the thumb of the FDA. They control not only our ingredients that go into our products, because they want to make sure that the growth takes place similar to what would take place with breast milk. But what we don't want to do is we don't want to scare a mom or dad who's looking at a product of infant formula, and we don't want them to put that down because they don't have other choices. We don't want them to go Google homemade recipes. We don't want them to grab almond milk, which we know doesn't have the ingredients to make an infant thrive that infant formula does, because we're mandated to put certain ingredients in to make sure that happens. And most notably, it likely has a lot more heavy metals in it than infant formula does. And so I hope that's helpful. I just wanted to go over a couple things that I heard the conversations talking about as y'all had talked about this bill a little more and provide a little history on the House side. I would love to answer questions if y'all have them with the time I have left. But thank you so much for allowing me to testify. I appreciate it.
Well, thank you very much. It's very helpful. And so I'll see, we're actually at the time we had devoted to this at this point. But committee, do you have questions?
Well, Oh, can I say one more thing, Madam Chairwoman, just real quick?
Yeah, please go ahead.
Also, with respect to kind of what's gone on, even since y'all were given the bill, since the House passed it, California is deliberating on this issue as well. And as I noted today, the FDA is putting out a study, which is a precursor for their action. So I don't know. I think that just counsels perhaps working on it over the summer, and then we can come back and we can put some pen to paper and write something that y'all could pass, in the next session. But it would give California a little bit more time to mature, and certainly the federal government to set their standards on the federal level. So thank you so much. I appreciate it. Sorry to butt in.
Thank you. I mean, the debate or the presentation from folks in committee has been what the trigger should be for baby formula. It doesn't seem that the baby food has been that much of a concern, so it's important that we've heard your testimony. We appreciate it. Thank you very much. Questions, committee, before we move on?
Just super quick. Thank you very much for your testimony. Comment just being that the FDA sometimes sets a pretty low bar in terms of, contaminants and additives and so on and so forth. So I don't necessarily always want to adhere to the FDA guidance. I'm looking at the regulations, the global landscape, which I really appreciate you sharing with us. I mean, it does look like the EU has a lot of really great, specific parts per million, guidance in their infant formula, and the US FDA doesn't have any limits established at all. That is disturbing, I would say. Even Canada at least has a limit on lead. So I just wanted to share my anxiety with that landscape.
Yeah. Can I give a quick observation on that?
Sure.
Okay.
Yeah.
So the Biden administration did propose this program that I initiated or initially talked to you about, which is called Closer to Zero. It is what it sounds like. It's the effort to get heavy metals in baby food and in infant formula closer to zero, because you're always going to have trace amounts. And so the Biden administration introduced their intention to do this. They didn't do anything on it. The current administration put the proposal out today, and they're gonna do something about it. We have actually asked them to just adopt the EU standards because they're strict, and we want moms and dads to feel comfortable with the product they're giving their babies. And so we would be totally comfortable with adopting the EU standards. But to answer the question of really why they haven't done it yet over spanning administrations is because they know that infant formula is a federally regulated product. They know what we do to curb for heavy metals right inside the gate of our facilities. We're testing the ingredients. They know that we test under European Union standards, and they are comfortable with that. But we have asked them to set a standard in the United States, and we would welcome that. And I think they will very soon. Well, thank you for the question. I appreciate it.
Last question, and then we need to move on. Go ahead. Senator.
So far, it sounds like California's doing something or looking into this to some degree. Are there any other states moving forward with infant formula language?
Yes. The only other state right now that's contemplating it or has a bill is New York. I would say California's deliberations are pretty mature. They're ongoing. New York does have a bill. And so, Maryland took a look at it in their session that ended a couple weeks ago and decided to just stick with just to stick with baby food right now. And the other states are Illinois and Virginia, who just have baby food.
So the concern is what are going to be the impacts to Vermonters, well, moms, infants, if we do pass this. I just want to make sure it's protected. I don't know if there's additional information out there that would be able to help us make a decision on this, but
Well, as we heard before, if the trigger is California, that's a large market. And so, that we can talk about that when we get back to final discussion of those important points. Right. Okay, Craig, thank you very much for being here this morning and bringing all the information that you have. Appreciate it. Obviously.
Yeah, thank you so much.
We get it. We understand. It's a tough
Okay.
place for all of us to be right now.
Yes, ma'am. Yeah, I understand. Well, thank you, and I'm available if you need me as a resource going forward. Thanks so much. I appreciate it.
All right, thank you. Okay, committee, we're going to move along to 9:30, and thank you, Bill and Allison, for bringing that testimony in. Appreciate it. So, Katie, we are in the midst of going through 938 with an eye to identifying decision point and actually doing some markup.
Miscellaneous tax.
We'll just hold a second. I think it's everybody here.
Amendments.
And I will say, also, what page are we on? 19?
19.
That's right, 19, section 2210.
Yeah, I went through it, find out. And I did have a terrific meeting with, the Vermont State Housing Authority and the Agency of Human Services on the rental assistance bridge program, and they have brought some language in that I think we should be looking at when we get to that section. I think, Katie, did you also receive that? I had them send it off to you as well. So when we get to there, we'll take a minute to look at that as well as what's in the bill.
I wasn't here Friday, but I did watch the video.
No.
It was exciting. Exciting viewing. So we are picking up where you all left off, right?
Oh, you've got it. Got it. You got it. I think we're gonna go back. Okay, so Katie, why don't you give us a heads up about where we've been briefly,
Sure.
and then where we are and where we're headed.
Okay. Katie McLean, Office of Legislative Counsel. So we started our markup last week. You opted to not see a new draft with the changes, but to keep working through the rest of the draft.
Yeah.
So I will hang on to the changes that you've made. You've made several changes. Probably the most noteworthy is, in the levels, moving permanent supportive housing out of the levels and into a service that is sort of across the board for, that individuals could receive while they were in any level. So there's a new section that does that.
Good.
Okay, 2210 is the household responsibilities. So we have this language again, within the funds appropriated for this purpose, the household shall qualify for services under the program if the household is physically present and intends to reside in Vermont as evidenced by active participation in housing, employment, or other AHS recognized plan. Agrees to a coordinated entry assessment that prioritizes the household for permanent housing unless explicitly exempt under this chapter. For example, the low barrier shelter doesn't have as much assessment for entry. Subdivision 3 engages with a lead case management entity such as a department of AHS or community partner to develop a housing plan and participate in employment, treatment, or other activities as appropriate, unless explicitly exempt from case management requirements under this chapter by federal law, and abide by program rules and refrains from misconduct.
Okay, so let's just stop there and think about this. So, this requires certain things of household applying to be in this continuum. So there's no requirement at the lower level for shelters.
The high barrier shelter, there are some requirements for case management. I don't know about coordinated entry specifically. But the low barrier shelter wouldn't have that requirement.
Right. Okay. And then, once they begin the coordinated entry process, then, at some point, they're going to have to agree to following through with a treatment plan and participation in employment, treatment, or other activities. Okay, so does that means they have to attend meetings if there are meetings for substance misuse? Or
I think it probably differs on a case by case basis, depending on what the family's needs are and what the ability to participate in different treatment or meetings.
Right. Understood. Okay. I know one of the concerns that was expressed is that you're mandating that people have to go through treatment. This doesn't actually mandate going through treatment, but that they participate in some kind of employment or treatment or other activities. So doesn't mean they have to take it seriously. It says participation. Oh, we'll think about that one. I mean, I do think that the concerns that have been raised are something that we have to maybe think about a little bit. So we'll put that as a little decision point, but come back to it at some point. Okay.
Okay, so I think we made it through A. That brings us to subsection B. The office, meaning OEO or a community partner, shall provide clear written notice to all applicants regarding penalties for fraud at the time of the application. The office of community partner shall not impose a penalty upon a household for good faith immaterial error that was corrected upon notice within a reasonable time period. Subdivision 3, a household that knowingly provides false, misleading, or incomplete information regarding residency, disability status, household composition, or other eligibility criteria shall be subject to termination of services within 30 days after receiving written notice from the department or a community partner. Subdivision 4, pending the outcome of a relevant Human Services Board hearing. The office may refer cases of suspected fraud to the Office of the Attorney General or State's Attorney for investigation and prosecution under applicable laws. A household may be terminated from the program for repeatedly refusing suitable placements following documented suitability assessments and reasonable accommodations.
Sorry.
Top of page 21, a member or members of an eligible household may be subject to immediate termination of services as necessary for the safety of others if the member or members are engaged in criminal activity or misconduct that is not related to a disability or to victimization related to abuse, sexual assault, or stalking. And then there is a definition of misconduct, which means documented behaviors that materially endanger the safety of others, involve the intentional destruction of property, or constitute illegal activity.
So the question is the definition, whether the definition is comprehensive enough or specific enough. But we see this question a lot. We probably should think about it this way. Yeah. I'm trying.
Next is the prioritization section. This specifies that the office, either directly or through a community partner, shall prioritize services within the funds appropriated for this purpose to eligible households who are homeless or at risk of becoming homeless and have a member who is one of the following: 65 years or older, has a disability, is a minor child, is pregnant, is experiencing domestic violence, dating violence, sexual assault, stalking, human trafficking, or other dangerous or life-threatening conditions, or is under court-ordered eviction or constructive eviction due to circumstances over which the household has no control. And then,
Okay, and this, so the word disability in there, it's important for us. And I know that we had flagged disability early on, but I just wanted to share. The more I think about it, the more that definition that's there is probably appropriate for use within the context of this fill in the homeless continuum. And so maybe what I started thinking about is maybe that back there in the definition, we need simply to say for purposes of this program or something like that. So then it holds for disability in this section.
So the definition only applies to this chapter,
That's
so,
all we need to know.
okay.
Yeah, okay. That's good.
Okay, in subsection B, proof of the eligible household's disability shall be verified by either a healthcare provider licensed or certified and practicing in Vermont, a determination or certification from a state or federally recognized agency or program that provides services to individuals with disabilities, or self-attestation by the eligible household, subject to verification by the state or community partner within 30 days when other documentation is not reasonably available at the time of the application. In subdivision 2, the presence of an eligible household member's disability shall be verified by the office or community partner during the household's initial application process and shall be redetermined annually if the household is still receiving services. An eligible household with a member who has a lifelong disability, such as an intellectual or developmental disability, shall not be required to have the disability redetermined. Subsection C, the office and community partners are to comply with the ADA and Section 504 of the Rehabilitation Act for the purpose of providing reasonable modifications, effective communication, and accessible placements. Program rules and case management requirements shall be reasonably modified, including the use of plain language as necessary to avoid discrimination against eligible households with a member who has a disability. Okay, that brings us to 2212, the time limits. So this section has already changed based on decisions that you've made. So first, for level 1, any temporary housing that is not provided in the form of temporary rental assistance through the program's prevention and diversion services shall not exceed 30 days per rolling 12-month period. Level 2 was shelters. The office, in collaboration with shelter providers, shall establish a maximum length of stay in highly structured shelters and low barrier shelters in rural or in shelter standards. Level 3, level 3 of specialized shelters. The department, in collaboration with relevant AHS departments, shall establish the maximum length of stay in specialized shelters, either in rural or in shelter standards. Level 4, this level 4 for permanent supportive housing doesn't exist anymore. Level 5 is hotels or motels. For the period between April 1 and November 30th of each year, eligible households may receive housing at hotels and motels with supportive services for not more than 70 days per rolling 12-month period. And between the cold weather months of December 1 and March 31 of each year, eligible households may receive continual services in cold weather use hotels and motels, which shall not be applied towards the time limit established in A. So the time between December 1 and March 31st, those days don't count towards the 70 days for the remainder of the fiscal year. In subsection B, the department can grant extensions to the time limits established in subsection A pursuant to criteria adopted in rule, including for an eligible household actively awaiting a placement in housing, treatment, or other services, for medical necessity, lack of reasonable alternative placements for a member of the eligible household with a disability, and due to imminent risk of health or safety of one or more of the eligible household members.
Questions, committee, as we're going along. Okay, but I think we'll keep going through and then I'm gonna make a recommendation at the end.
Okay. 2213 is case management services. Each eligible household shall be assigned a lead case manager.
I have a question there. So it says a lead case manager, does it is it important to say it's a lead case?
As opposed to just a case manager.
management, I know, the distinction being, you know, if you have a lead case manager and that person goes away, do you just have case management? Is it flexible? Is it not? I don't know.
I think the thing that I'm finding most concerning is it's a one-way construct. But one of the problems we've had is we don't have enough case managers. And so you said, yeah, we're setting this all up, but we don't have the shelters, the staffing, or anything else. And people can be thrown out for being not nice, which they frequently aren't. I'm not sure how we're improving the present system. I want to hear from the agency that they have staffing. Because we've heard this, was it 5 years ago? It's after COVID, all hands on deck. We are ready. We've got this under control. There was nothing ready or under control. And we've struggled up from there. So at some point, I'd like,
Definitely a good point, Senator, and there is time in here. Remember also, it takes a couple of years for all of this to get fit up. However, your comment is well taken. This has been going on for a long time. So it's not in any way dismissive of the work that the agency is doing. They're very dependent on the same conditions that everybody else is dependent on. Inflation and workforce, et cetera. But if we're going to do this, we need to be serious about it and make it happen. So I don't want to be back here for this. Maybe for some fine tuning improvements, but well, point well taken. So anyway, well, I just saw the word leave when I was looking through earlier as well. And I know others have pointed that out. So maybe when I think about whether it's just case management. Yeah.
George McLeod, yeah, we learned of that child dying.
Yes.
Yeah. Was that we fired or gave early retirement to all the middle management, senior social workers who would probably be your lead
Case managers.
people, case managers. And we had all these newbies, and you can have a master's in music and become a social worker for the state of Vermont. And we didn't have the people to train you. And that's why staffing is really important.
So. I think you're right, Senator. So on page 45, as an example, it says the household may request a specific case manager.
Oh, gosh. I don't
Just so you
think,
know.
I don't think that, I mean, we're almost, Katie's gonna get us there. That is another,
Okay.
that's another little flag I was gonna put up. I mean, everybody will be asking for the same person.
Yeah.
That would be fun.
Well, if we have one good one, you can bet that.
Yeah. Okay. All right,
Okay,
so keep going.
sure. Well, how would you like to proceed on lead? Do you want that word on line 19 in, or have you not made a decision on that yet?
Well, I don't know. Let's just put case management in there and see how that.
Assigned a case manager.
Yeah.
Okay.
It's like case management or case manager.
Okay. So each eligible household shall be assigned a case manager except where specifically exempted for certain services, which may be from any AHS department or community partner. Case management services provided pursuant to this chapter shall be informed by the acuity level of the eligible household and include individualized supports that connect an eligible household to public assistance, healthcare, employment, permanent housing, and other services. A household may request a specific case manager or a change in case
Is
manager.
there anyone who wants to leave that sentence in? I know you have your hand up, but I'm not going around the room yet. So it's just for the committee. I'm not thrilled with that sentence. I don't think that people should be requesting a specific case manager. They can complain and they can ask, but I don't think it should be statutory. And there may be some mitigating circumstances against doing that.
So-
Staffing.
But a request isn't necessarily, that will be granted.
I know that, but then if you request and you're requesting it's turned down, you may have an appeal to the Human Services Board. I don't know what that means from a statutory perspective. But we can come back to this in a couple years when we see how it works.
See, it seems like a nice idea to give people some agency, but I understand.
Well, I know it gives people agency. I agree with that, but it could be an issue. Let's take it out for now and then we'll see what happens if we get through the bill. The other hue and cry out in the real world. I get it.
Section 2214 is the needs assessment. OEO or the community partner shall provide advice and consultation to the Department of Housing and Community Development and its completion of a needs assessment that identifies gaps in services for households that are homeless in the state and includes recommendations to ensure the provision of equitable services throughout the state. It's my understanding that this is an existing needs assessment requirement that Housing and Community Development is already asked to do. 2215. Notice, appeals, and right to a fair hearing. OEO or a community partner shall provide written notice to any applicant or household whose participation in the program is denied, reduced, suspended, or terminated. The notice shall include the specific factual and legal basis for OEO or the community partner's decision, the effective date of the action, which in the case of termination, reduction, or suspension of services shall not be sooner than 30 days after the date of the written notice, and the household's preferred method of communication.
Okay, this is all related to the Human Services Board.
We haven't gone to the Human Services Board yet. This is the
Getting just-
information that the office, the OEO or the service partner provides if a person is terminated. This is sort of the explanation of why a termination
Okay.
or reduction
Okay.
occurred.
Understood.
Okay.
Keep it up.
So also in this notice is a statement of the right to request a fair hearing pursuant to this section and clear instructions in plain language on the process and deadlines for filing an appeal. So that's all part of the notice.
So is this different from the current notice for making appeals to the board?
I would have to check that statute, but the timing could be different. And I don't know what the notice requirement is off the top of my head. I'd have to double check.
I'll simply say, sorry. When we get to the whole Human Services Board piece, for me, looking at Human Services Board process and decision-making, it's a whole bill. It's a whole structure. We've been through this in this committee, and I know how long it takes and the difficulty of making decisions around it. So I'm less enthusiastic. Me personally, having been through this, and knowing what's there about including all of the Human Services Board stuff in the bill. So, and to the extent to which this is part of that, I mean, something we'll have to understand. So just to say that, put it out there, this is a huge red flag for me. And I think it should be for all of us because it takes time to dive into all of the word process and decision making. I know there's a backup. I know that people are concerned. The other side of that is that as this is implemented, maybe some of that will be resolved. Never know. So anyway, just I'll leave it there for now.
I'm thinking for your question a little bit as I'm sitting here. Your question was, what are the notice requirements right now? So the Human Services Board hears appeals from multiple programs.
Yes.
And I would think that the notice requirements aren't as specific to the board as the program themselves. So here, in a case where we don't have a current program, there probably aren't specific notice requirements about termination from housing and a length of time for an appeal. So this is probably the only place that this
Okay, so
appears.
let's leave that one right there.
Okay.
Okay, good.
I'll move on to subsection B. An application for or recipient, an applicant for or recipient of assistance pursuant to this chapter may file a request for a fair hearing with the Human Services Board pursuant to 3 BSA 3091. When an applicant for assistance under the program is denied in whole or part, the household benefits are terminated, reduced, or suspended, or the household believes that benefits have not been provided in accordance with applicable rules or policies.
When does this section of the bill go into effect?
This goes into effect July 1, 2026.
Okay,
Subsection 3, an applicant or household shall file a request for a fair hearing within 60 days after the date of the written notice pursuant to subsection A. And subsection D, if the household files a request for a fair hearing within 14 days after receiving notice, the office or community partner providing notice shall continue to provide services under the program without interruption until the decision is issued by the Human Services Board unless, so this distinction there is you can file the request for a fair hearing up to 60 days, but if you do it within 14 days, you can continue to receive services while your hearing is pending, unless top of page 27, the household voluntarily waives continued services or the household or household members' continued receipt of services poses the risk of safety to others.
so this is the Human Services Board section.
Yeah, there's more. The hearing shall be conducted in accordance with due process standards, including the right to present evidence, cross-examine witnesses, and be represented by counsel or another authorized representative. The Human Services Board shall issue a written decision that sets forth findings of fact, conclusions of law, and the basis for its decision, and the process for appealing the decision to the Vermont Supreme Court. The Human Services Board if it issues 20 substantially identical decisions brought by applicants or recipients of this program, the department and program partners shall adopt the board's interpretation as part of its administration of the program, and the department shall revise the program rules accordingly.
So, okay. So for all of this, the important piece is that there's a right to appeal to the Human Services Board. That's the important piece. The rest of it is procedural, that is maybe not duplicative, but different from what currently happens with the board. And so in order for us to go through all of this, it's what I was indicating before, it's a whole new way of looking at board process. So my suggestion is that we keep statements in there about allowing for a fair hearing and appeal. And maybe there's some timing in here we should include, but to have a full-blown discussion at this point is interesting. So let's hold the thought and you're hearing my thoughts on this. That's all I'm saying. Senator.
Did the agency department ask us not to do that because the board was already overwhelmed with some of the earliest testimony we got? And then we're very concerned about the board. I think they said they were working it, figuring or something, and that the board was already backed up, and to put this all on it would grind everything to a halt.
And we'll have to sort this one out, but for now, it is a big deal.
Yeah.
It's a big deal. Okay. You're hearing my thoughts.
Okay, so noted. Okay, I'll keep moving. 2217 is rulemaking. The department shall adopt rules under the APA for implementation of the program addressing at a minimum requirements for community providers participating in the program, standards for highly structured, low barrier and specialized shelters, documentation requirements for household eligibility, including disability, required elements for supportive services, including case management, the creation of a brief, standardized initial assessment form that may be completed by hand, electronically, or by telephone, a process for issuing timely written approval or denial notifications to applicants, a process for issuing advance notice to households when the household is being terminated from the program, applicant and household appeal procedures, time limits for program participation, including procedures for extensions, expectations for the office's oversight and quality monitoring, and other subjects as deemed necessary. So that would be part of the rulemaking process.
So, it is a pretty wide open rulemaking process. I think committee what we might want to think about is how to fine tune it a little bit. So if they're writing, for example, rules about eligibility, including disability, we've already got a very concrete, I think it's pretty concrete definition in the beginning. So I'm trying to sort out what they would say differently from it. Maybe it's procedurally how to document. We don't want it to be onerous for folks. Already difficult. So think about the level of the levels, the rule, and how maybe think it's wide open. Having been on LCOG for a long time, I know that this would open up a lot. So we have to think about this one.
Okay. On the top of page 28, subdivision 3, where you wanting to say documentation processes for household eligibility instead of requirements.
Which one are you on, Katie?
You had read, so top of page, we're on different pages. So I'm in 2216. Subdivision 3 was the one that you referenced.
I did. It was just an example.
Okay,
As an example, that's all.
but no change at this
But
point.
I don't know what changes we can make to be somewhat more prescriptive on the rulemaking process. That's all.
Okay, I will wait to hear more.
Yeah, it's through, I think, required elements for supportive services, including case management. And then brief, standardized initial assessment. Maybe I'm being too fussy because I think we need to trust the folks who know what they're doing. On the other hand, we want to make sure that we don't have something that leaves people stranded. Anyway, committee, go through this section a little bit with an eye to rulemaking. That's all.
Okay. Next is 2217 reporting. Annually, as part of the department's budget presentation, the department shall provide a status report addressing each level of the continuum. Minimally, the status report shall address the number of households served at each level of the continuum, the average length of participation for households within each level of the continuum, and the rate at which the household successfully transitioned to permanent housing. The number of households diverted from entering shelters or hotel motel placements through prevention and diversion services. The utilization of hotels and motels, including the average nightly number of rooms used. The average and median length of stay. And extent to which hotel and motel usage has decreased relative to the prior fiscal year. In subdivision 5, housing stability outcomes, including rates of return to homelessness within 6 and 12 months following exit from the program. An assessment of regional capacity and access to services, including identification of geographic areas with unmet needs or disproportionate utilization of emergency housing resources. Total expenditures by continuum level and funding source, including state, federal, and other funds, and an analysis of cost efficiency across hotel and motels. Across housing models, And subdivision 8, any operational barriers to implementation of the continuum along with recommendations for administrative or legislative action. So that's part of the annual presentation as part of the budget presentation.
It's a lot. I mean, it's good if we can get all of that. I'm sort of looking at Miranda Gray and whether or not there's capacity to do all of this right now. So we'll have to sort that one out, or whether it's a matter of understanding what exactly can be done and then establishing a goal for these to happen. Thinking in two ways. One, this is stuff we really want, but right now, can we get it? And then can we establish this as a goal and then say, come back and tell us when and how?
Well, also, is this taking the place of a different report or is this on top of all the other reports that they're doing?
That's a good question.
Well, right now they're doing a monthly report.
We get, oh yeah.
But I'm trying to think there are other reporting requirements. I'm trying to remember if there's a similar.
So this is a little flag piece. Anyway, we want to know capacity. We don't want this to overwhelm the work of what needs to happen.
There's a monthly report there. There is still a monthly report.
How the data is collected, how it can be collected, what is the potential for this. We don't want to get in the way of having this data. Okay, number one, not saying we don't want it. And I'm not saying that the agency shouldn't provide it. But it's whether or not the capacity is there right now, or whether we work toward that and out.
What about every 2 years is in 3 years? What are you doing about negotiation? I don't know.
Yeah. Not a little problem. Okay. And, okay, keep going.
Subsection B is annually also part of the department's budget presentation. The department is to set goals for increased housing capacity, including permanent supportive housing, permanent affordable housing, and shelter beds. The department is to provide data pertaining to the increased shelter capacity and the extent to which shelter capacity meets the needs of eligible households experiencing homelessness each year.
Okay.
And then C is the monthly report that I was thinking of.
Right.
So this is asking for what is a substantially similar report to the report that is being produced now on a monthly basis that would be posted on the department's website. Broken down by the levels in the continuum.
It seems like before we even start, we should have the report on shelter capacity versus need. And work from there. Rather than do all this and then report on shelter capacity. Because that's what's missing is the foundation.
Mhm,
We have X number of homeless people
mhm,
for X reasons,
mhm.
and we have X amount of capacity. And how do we fill the gap?
Good suggestion. Hold on to that thought.
Okay.
Keep going.
Section 5 is the merger of the two continuums of care. In order to promote effective use of resources and continuity of care, OEO is to work in collaboration with the two continuums and US HUD to establish a single continuum of care in the state by October 1 of 28. Prior to this, on January of 2028, OEO is to submit a written report to the various policy committees summarizing efforts to establish a single continuum of care pursuant to this section, recognizing that this isn't something that unilaterally can happen at the state level. Section 6. Okay. Section 6 is a section that would be added to the chapter that we have just looked at. It takes effect at a later date. Human Services talked about this section taking effect after there was one continuum of care, which is why it's set for October 1, 2028. This specifies that any grant or other agreement executed by AHS or its departments shall require a community partner as appropriate to participate in the local housing coalition or other group established to assist eligible households who are homeless. Utilize the coordinated entry assessment for eligible households who are at risk, who are homeless or at risk of becoming homeless. Utilize the appropriate planning process and options for an eligible household transitioning into permanent housing, including for eligible households with an individual who has an intellectual or developmental disability, older Vermonter, or individuals transitioning from a correctional facility or hospital, and measure performance outcomes, including diversion success, time to housing, and housing retention. So that would be part of grants with community partners as of October 1, 2028. Section 32. No, page 32, section 7. Sorry.
Got it.
Sorry,
Understood.
Can I ask a quick question? I don't know why I didn't ask this before, but what do you mean by measure performance outcomes? What is that referring to?
Measure performance. That there would be a requirement that entities under agreement to provide services as community partners would measure their performance outcomes.
I guess. That's.
Yeah,
I imagine
there's specificity here that isn't in the rulemaking process, but it is in the grants.
Yeah.
Yeah,
Okay.
I wonder if there, it would be appropriate to have language in the rulemaking that specifies what measures, what performance measures. There's some language about quality improvement.
Yeah, they're picked up.
But maybe that's, oh yeah, quality monitoring, but that maybe that's where you say something more specifically about specifying the types of performance measure outcomes. Okay.
Yeah.
I will add that.
Okay.
There might be some others under the rule piece too.
Okay.
I am thinking that we want to. Good, we're almost to the rental assistance and we have folks in the room who have a proposal, so you see what we can do. Yeah.
Section 7 is your transition language. So this specifies that the department and community partners do not have capacity to fully implement the continuum on July 1, 2026 when it takes effect. The department, through the office and community partners, shall implement the program to the fullest extent of their ability in fiscal year 27, while developing capacity to fully implement the program in fiscal year 28.
Is that in any way redundant with what we have previously? I don't know.
No,
Mergers, okay.
I think the alternative to this language would be to break apart the chapter that we walked through, with some pieces taking effect at different times.
Yes,
So what this is allowing to happen is allowing the program to all be enacted as one coherent chapter at one time. And this gives permission that in fiscal year 27, not all of the pieces are necessarily going to be in place, but in 28, they would be. This is our rulemaking timeframe. So pending adoption of permanent rules, DCF is to adopt and maintain emergency rules, which shall be deemed to meet the standard for emergency rulemaking. Emergency rules required by this section shall take effect on July 1, 2026, and at a minimum address the topics listed in 2216 that we went through. And then in subsection B, unless extended by LCAR, the department shall on or before October 1, 2027 adopt permanent rules for the program. So you will have emergency rules continually in place until by October 1, 27, there would be the permanent rules in place. So that gives a more than 12, what is that? Almost a
Could be 18
15.
months, that's usually.
It would give about a 15-month window for full rulemaking.
Yeah.
And I've heard 9 to 12 months is sort of the window for a rule. So
Okay,
that
well,
gives a
we'll
little
live
bit
with
longer.
that. Sometimes it's longer, but we'll live with that one.
Okay, there is language that you could get an extension from Elcar.
Yeah.
Okay, implementation status report. So by February 15th of this coming year, DCF and OEO, just OEO, I'm sorry, shall present a progress report to the policy committees on the implementation of the continuum. The office's presentation shall include an initial draft of the department's permanent rules, and any recommendations for legislative action. Okay, section 10 is standing up a program for households experiencing domestic and sexual violence that is separate and apart from the continuum that was created. I'll move over that. And that brings you to the Bridge Assistance Program, which I know you received alternative language on.
We did, and it would be, I think, helpful to look at that language, and then we have John O'Farrell in the room and others who can maybe speak to that. So why don't you put that, the rental assistance piece up, and the way it was presented to me of what is that there's agreement between the two groups, the Housing Authority as well as the Agency of Human Services. So let's look at this and what it says. And then this is the first time that we've seen it. It's also probably the first time that folks in the room have seen it. That's okay. It's a good thing. And we'll see what the effect is. Why don't we look at that?
Okay, so
Maybe
maybe,
you make a teensy bit bigger.
let's see. How does that look?
Oh, that's good.
Okay, so you'd be retaining subsection A as it came over from Human Services. That the program is established within the State Housing Authority for the purpose of linking households who require rental assistance to permanent housing when the household does not otherwise have access to HUD rental assistance. The program shall be accessible to eligible clients served by each AHS department. Then some changes to subsection B. Instead of the program shall not be available to a household for, shall be available for not more than 24 months, etc. Language that the program shall not provide the full amount of the household's rental payment and shall not be a permanent voucher. The duration of the program assistance shall be temporary and determined based on the specific needs of the, I would say eligible household, not clients. Let me just make a note for myself. Household.
Eligible household.
As established by AHS and the Vermont State Housing Authority pursuant to subsection D. Program payments shall be made directly to the Vermont State Housing Authority to a household landlord. And C, some changes, instead of referencing the whole program, let's say that the program shall be accessible to eligible households. Thank you. Absolutely. Served by each of the AHS's departments, the priority given to those exiting. Yeah,
Exiting homelessness.
exiting homelessness, is that right?
Entering permanent home.
With priority given to those,
That makes sense.
that does.
Yeah, it does.
Okay. The State Housing Authority and relevant departments of AHS shall jointly work to develop a plan that incorporates existing rental assistance for Vermonters exiting homelessness, funded by the agency and its departments to the program established in this section. And establish eligibility criteria and any prioritization that may be necessary for the use of funds appropriated for this program and the appropriate length of bridge assistance. Assistance under the program.
This is posted on our page.
Yeah, it was under
Brendan.
Brand, Vermont State Housing Authority or AHS.
A new section in E, AHS shall collaborate with the Housing Authority to develop a framework for establishing a unified housing voucher program that consolidates voucher assistance currently provided through the agency's departments In developing that framework, the agency and housing authority shall analyze the fiscal implications of consolidating existing voucher programs into a unified program, including projected costs, potential efficiencies, and impacts on funding sources. Assess projected impact to the total number of individuals served and on distinct populations, including but not limited to individuals exiting homelessness, individuals facing eviction, individuals with mental health disorders, individuals with disabilities, and any other populations currently served by department administered voucher programs. Subdivision 3, identify administrative, operational, or statutory changes required to implement a unified program and propose options and recommendations for the structure, governance, and implementation of the unified program. AHS and the Housing Authority shall report their findings and recommendations to the relevant legislative committees by December 15th of this coming year.
So we just need to put committees in.
Yeah. I can figure out the mechanics to make this work.
Okay, so, I'm gonna ask the presenters of this amendment to speak to it. I don't know who wants to do that, Jenna or?
Sure. The record, my name is Kathleen Burke. I'm the executive director.
Jenna's not here.
I'm not Jenna.
She's not up there.
Okay.
That's okay. Okay. Sorry.
I'm Kathleen Burke. I'm the executive director of the Vermont State Housing Authority. Thank you, committee members. Yes, the Vermont State Housing Authority has worked collaboratively with the Agency of Human Services, Brendan Atwood and his team to present the legislation that is being considered today as part of this subsection 11. It deviates from the original, from the bill that came out of House Human Services, in that it eliminates time limits from the legislation and directs the Vermont State Housing Authority and the Agency of Human Services to work together to develop appropriate time limits programmatically through policy as opposed to legislation. It's important also to call out that this is a bridge rental assistance program. And so a component of this that will allow the program to be successful over time is that the Vermont State Housing Authority, in the role of administering this bridge program, will also position folks that are receiving state-funded rental assistance on their waiting list for a federal housing choice voucher. And so there's a plan to transition families from state-funded assistance to a federally funded housing voucher.
6 months ago, 3 months ago, the emergency board was looking at a federal pullback and the loss of Section H vouchers. And I'm wondering, if no sign that Washington is letting out. I believe President was quoted as saying housing vouchers are subsidies for landlords or welfare for landlords. I think it might have been his term. So we basing this on a solid foundation. Is, you know, we're going to transition people to something that may not be there. We've had to return vouchers, right?
We've been shoving vouchers to that. I have a couple of comments. One is, I think, because of the uncertainty around federal assistance coming to the state of Vermont, this program is more important than ever if we were going to continue the state voucher program, if we're going to continue to transition families out of homelessness into permanent housing. It's absolutely critical. As it relates to, the federal housing policy, specifically as it relates to housing and urban development, and the program is funded by housing and urban development, we are going through a very uncertain time. It's a rocky road. I've been in the business administering the voucher program for the State Housing Authority for over 35 years. I can tell you there have been waves over time. We went through sequestration many years ago where there was a significant pullback in federal resources, right? We built that back. And so I do anticipate that, for the next couple of years, things are going to continue to be tight. Things are going to continue to be uncertain. However, our agency has what we call a move-up preference. What that preference is it positions families who are receiving state-funded rental assistance on the top of our waiting list for our house of choice voucher. They're given preference over other families. And so should this language be adopted and passed, then families participating in BRAP will also be elevated to the top of the waiting list. There may continue to be a wait, but I believe I'm an optimist by heart. This too shall change. We will be issuing vouchers again to our waiting list. And when that happens, this will be the cohort of folks that will be offered that assistance.
Uncertainty.
Mhm.
Yeah. Thank you for your comments and your
Absolutely.
optimism. We all need that optimism. Understood.
Brendan, do you have anything to add?
No, Brendan Atwood, Policy Director for the Agency of Human Services. I echo Kathleen's comments. We're excited to work on this for us because it covers the entire agency, or at least many other departments. We want to make sure that we're doing our due diligence to plan this out right. So that's kind of the intention behind taking the time here. But otherwise, we'll hardly agree with Kathleen's comments. We look forward to working with them on this.
Okay. All right. So this is, why don't we'll put this in and we'll consider it. And I'm sure we'll hear comments from folks, but having the state program move ahead as a bridge program, I think is critical. And, see where we go with it. And thank you for bringing it to us.
Absolutely.
I know it's hard. Why don't we see how far we can get? We probably can't. Let's put a hold on just getting to the last the last part of the bill. We have payment rate structure and shelter services. And one of the things that we have to think about in here is how we're paying for it all and how the money is distributed. So we'll just consider this would be a good place to take a stop. And when we come back, we'll be on page 35. And then we'll be moving forward again. And so the question about where does the money go? We've got like 21.8 or $21 million. It's right there. We have some money to look at and how it's put in place. And I have some questions about maybe what's not in here and then how we can include some things that are not here. But so thank you, committee, for all this good work. And thank you all for being in the room. I know you all want to comment right away. I get that. If it were me, I'd be wiggling in my seat. Understood. So we'll keep working on it and allow for the committee to make some decisions, and then we'll have that conversation around the room as we do that coming up pretty soon. So we're going to move on to other things right now. Well, thank you, Kathleen. I'm sorry. I thought
I'm not offended.
we're good.
We're good.
May 8th is our last day.
That we are getting.
Yes.
What are you doing next?
We're gonna do the two bills that are on the calendar.
On your calendar?
Oh, we have those. We have the calendar bills upstairs. Senate calendar. One is Michelle's and one is yours.
Yeah.
What are the numbers?
Fine, I'm going to say this.
157 and 239.
Oh,
Oh, what's 239?
I guess,
That was doing now.
yeah.
Yeah, we'll do that first.
I'm gonna go upstairs.
Then we're gonna do baby food. Then we're doing all the others. I don't
Let's
know
take
how
the
far
time
we got.
when she gets to 6.
Huh? I don't know how far we got, to be honest. Child abuse is.
Yeah, I'll let you have some. Oh,
Adult
yeah,
protection
that's one of the
services.
four that I thought
Is it,
we were
is it,
doing.
what is it? What's 157?
Recovery residences.
Oh, recovery.
I'm ready to go with that one.
Okay, let's do it because I'd like to report it on the floor.
Okay.
Hold on a sec.
Sure.
Oh, before we dive into that one, I want John here before I do that. Okay, he comes back. So we're gonna go to the bills that are up on the calendar, returned to us from the House first. Then we're gonna go back to the calendar, agenda that we have in front of us, which starts out with 536, 660, 816, and we'll see how far we got, because we have a half an hour.
Okay.
Then tomorrow we'll come back to it.
So I have pulled up on my screen, S-157. This is not the as passed bill. I will make it bigger. But this is the final committee report of Human Services. And the reason I'm showing you this version is because one, there are no changes on the floor. And I have this, PDF that retains the highlighting of their changes. So I thought that this is maybe the easiest way to see what has been done. Like I do in this committee, I sometimes use two colors of highlighting. That is not meaningful for our purposes. Just know that if it's highlighted, there was a change from Human Services. So one change they made in the definition section was there was a term substance abuser. And the committee decided to change that to individuals with substance use disorder. It appeared a few different times. So you'll see that change has been made throughout. Instead of substance abusers, individuals with substance use disorder. In the definition of recovery residents, instead of tenants, they used residents. So it means a shared living resident supporting residents recovering from substance use disorder, and provide residents with peer support, assistance accessing support services, and other community resources related to substance use disorder. So those are our changes in the definition section. You'll see that this keeps repeating individuals with substance use disorder instead of substance abusers. Section 2, no changes to the work that you did. Section 3, this was the section that had the recovery residents having if they wanted to immediately exit or transfer a resident of the recovery residents, there was a process that had to be followed, including different types of notice. So this has been changed by the House. So one of the elements is that that the individual would indicate that by signing a residential agreement, a resident acknowledges that the recovery residents may cause the resident to be immediately exited or transferred to alternative housing for behaving in a manner that impacts the health or safety of other individuals residing, working, or volunteering in the recovery residence, such as the resident violating the recovery residents' substance use policy, repeatedly refusing to engage in services or programming, being charged with a criminal offense, engaging in theft, materially interfering with recovery residents, or engaging in acts of violence that threaten the health or safety or other residents, recovery residents, staff, or volunteers. So sort of the discussion around this change on lines 13 through 15 was that everything comes back to safety, that the reason this is in place is for safety. So they sort of led off with the reason for immediate exit or transfer would be related to a behavior that impacts safety. And then everything else is appearing that had been in the Senate side is appearing as an example of that impact on health and safety. Does that make sense?
Yeah, it does.
There was maybe I'm remembering wrong, but if they were gonna be exited, there had to be like a plan in place.
This doesn't, that there would have to be like a transitional spot. Yeah, that hasn't changed. You'll see that. Oh, well, there is a tiny change, but it's still there. And so this subdivision C mirrors the language we just looked at. So they have to sign that they acknowledge that that this type of behavior could result in exiting or transferring, and then to be exited or transferred, the individual would have to have behaved in that manner. So this is tracking the language we just looked at. Here is the language that you're asking about in subsection D. The recovery residence has provided or arranged for, instead of a stabilization bed, a re-engagement bed, or other alternative temporary housing. And subdivision E, the recovery residence has provided written or electronic notice to the resident containing the date and rationale for the temporary removal or transfer and options for returning to the recovery residence. So that's a new condition. Another new condition or added language. The recovery residence has established a grievance process approved by VTAR or another certifying organization approved by the department. So there would be a grievance process in place for the immediate exit or transfer. And then there's this new subdivision 3 at the top of page 6. Notwithstanding 4460, which is that a landlord can't go into a tenant's rental property without sufficient notice. So notwithstanding that, a recovery residence employee may enter the recovery residence at reasonable times as necessary to carry out functions related to the operation of the recovery residence. Subdivision 4. This is a change to the definition of recovery residence. Unlike the definition in the Senate had tracked the definition in section 1. However, here Human Services made a decision that this exit and transfer policy would only apply to certified recovery residences. So what this language does is it says that as we're using recovery residence in this section, it means the definition in section 1 plus they're certified. So that is the change there. No changes in subdivision 4. Section 5 is the rulemaking section. So the only change here is that at a minimum, the rule shall set forth data collection standards and reporting requirements for certified recovery residences, including data elements and frequency, exit and transfer data. They wanted that collected because if you remember, we have a report now that's being sunset. So this would continue to collect that piece of the data. And that's it. So those are your house changes.
Committee, any questions about those? Any red flags for you on it?
Well, sorry, can you just, I'm trying to find the statute here, notwithstanding the.
4460.
Yeah,
Mhm.
if they can go into they can enter those. Can you?
Yeah. Do you want me to pull up the statute? Yeah.
Find one. Okay, so that's, so.
There's a realtor act.
Oh, so it's just a 24-hour notice? Okay.
That's generally to enter.
Okay.
I'll have to tell you how.
Away in Marshfield and,
Can't wait to finish.
How does the notice have to be delivered? In writing or?
Remind me to tell you how professional tennis players are regulated with the use of disallowed drugs.
Oh, yeah.
Amazing.
we could do.
Okay.
This is what we're notwithstanding. A landlord may enter the dwelling unit with the tenant's consent, but shall not be unreasonably withheld. A landlord may also enter the dwelling unit for the following purposes between the hours of 9 a.m. and 9 p.m. on not less than 48 hours notice. When necessary, to inspect premises, to make necessary agreed repairs, alterations, or improvements, to supply agreed services, or to exhibit the dwelling unit to prospective or actual purchasers,
It's been a long morning. Take your time.
mortgagees, thank you.
That's a big word.
I'm sorry. Tenants, workers, or contractors And then in subsection C, a landlord may only enter a dwelling unit without consent or notice when the landlord has a reasonable belief that there is imminent danger to the person or the property. So that's what's being not withstood in that section and allowing an employee to go in to manage functions related to the operation of the recovery residence.
Meg, go ahead and comment.
Like post action circles. This is actually really what the providers feel is technical cleanup language, because how a recovery residence operates, there are actual offices in the residence. So this is actually just saying that the employees of a residence can enter their office space and, as they need to carry out the functions of the residence. They're co-located.
Got it. Okay.
I would say that this is broader than office spaces though, yeah.
Definitely broader, but also I think critical, given
Yeah,
what the residents represent.
you have a stash of something you're supposed to
Not
be
to have.
avoiding. This isn't a standard rental. This
No.
is a recovery facility, and you are then endangering your recovery if you haven't already gone off. And you are endangering by putting temptation in the way of everybody.
So they can go into the individual rooms.
I've got, when I was on economic development, we had a lot of that change that the landlord tenant, right? These aren't
Yeah,
standard rental.
right. So committee, are we, any, I guess straw poll, you okay with what the House is proposing at this point? Because I would be happy to report it up on the floor.
Yeah, I like a lot looking for them.
I do too. I like something changed. Yeah.
I'm a little worried about privacy issues.
Well, that one is always that's gonna continue to be, little hot target button, whatever you call it. Straw poll. Good with it? Okay, that's all I need to know. And I'll get it, if I can get a printout of the colored copy now, I'll make
Oh,
it up on
I will
the.
send it to you right now.
And then, so Katie, while you're here, I know the other bill that's up there is Michelle's, and Michelle sent us all the information. And I read through it all last night. I'm hoping that you also read through it. So, tisk, tisk, it's on our webpage.
Yeah.
And we'll hold that one then until everyone has had a chance to look at it. Fine to me, but I'm just one person.
Where, can you tell us?
What is it?
Orient us to where we're going.
What number is it, Calista?
239.
239,
Under,
Michelle Childs.
oh yeah, there's.
She sent us 3 documents.
You want us to look at the house, which is close a little bit better.
Yes, and so what we'll do is we're gonna move right over to 536, which was the heavy metals and
Yeah,
baby
let's
food products.
Do those.
And we've heard a lot of testimony.
Yeah.
The biggest, we just heard from the baby formula piece. There is a trigger in the bill. Katie, remind us what the current trigger is.
Yeah, it's if either California or 2 other states pass legislation with regard to infant formula that meet that are substantially similar to what Vermont is doing with regard to 3 factors. Sorry, I just switched documents here. I'll pull it up so we can look at it together.
Yes. I did read Michelle's thing and I'm trying to. Yes. Yeah. Yeah, no, I thought it was reasonable.
Okay. So here, let me see this. Yes, okay. So here are effective dates. Section 2 is the infant formula. So this would take effect upon the Attorney General's written confirmation to the Speaker and the Pro Tem, which is to be posted on the General Assembly's website, that either California or 2 other states have enacted legislation with the requirements substantially comparable to the requirements of this act regarding all of the following. First, that the prohibition on the sale and distribution of infant formula that contains a toxic heavy metal exceeding US FDA limits. the required testing of infant formula sold or distributed in the state for toxic heavy metals, and the labeling of infant formula and the provision of information about toxic heavy metals in infant formula. So basically, this is saying all the elements that you're putting in place in section 2 have to be substantially similar to the legislation that passes in another state. So if another state were to do testing but not labeling, the 3 elements wouldn't have been met.
It would have to also require label.
All 3 of these elements, yeah, prohibition on sale and distribution for exceeding FDA limits, testing, labeling.
Right. I guess that.
Okay,
What's the
The
option?
question is, do we want to change that trigger? And we did hear from folks from the baby formula industry. But we also know that other large states besides California are also looking at this, so could be,
You want to look at states or population?
it's states,
I know.
because that represents population.
Well, I think every state has different population.
I know, it could be a smaller state.
Right.
No question about it, but right now, the states that are looking at it are the larger states like New York, Virginia, Illinois, Maryland. Those are the ones that have been looking at this and working on it. So that's what we were told. Anyway, just committee,
I'm okay with it.
you're okay with it? I'm okay with it.
I'm not okay with the infant part. I'm okay with the rest of it.
Okay. Fine.
You mean the formula?
If it sounded like affordable, it's all.
Just get it into the last second. Yeah, but okay.
Although there's nothing, there's no regulation for any level of any of these chemicals through the FDA.
Correct.
So we are really out of sync with the world on this one. And I know everyone says, oh, well, it's in the water that they make it with. Like, put filters on that water. You can make accommodation for that. Right now, there isn't any. And I understand what we're hearing from the formula industry. We also know that there aren't a lot of them out there. How many, Bill, how many baby formula manufacturers are there? There's 6.
I don't know the total number. There's at least 3 or 4 large generic ones.
Yes, so they're big ones.
One went down.
Yeah, so they're doing well
Yeah.
in the marketing world. So.
To entertain the motion?
Yeah.
Okay.
But
Sorry.
what's your last comment?
Absent any other changes, there are at least 3 timing issues that the House language does not address that would need to be addressed. First, it's not entirely clear whether the Vermont law would be effective on the passage in the other states or upon the effective date in the other states, number 1. Number 2, the underlying bill has a provision to allow the sell-through of existing inventory, which is not addressed for infant formula here. And 3, any label that would be required by this legislation would have to be approved by the FDA. And that could be a lengthy process. There's no accommodation via bill to allow for how long that will take. You could end up in a situation where Vermont requires a label that the FDA has not yet approved, which would obviously be a problem.
Well, they would have to have it approved.
So,
Yeah.
but regardless, so that's not addressed in the House language. So apart from all the other issues.
Katie, your thoughts?
Well, with regard to the first one, I was just looking at it. It says 2 other states have enacted. So that seems pretty clear that they haven't enacted it, and it doesn't refer to when it takes effect. It refers to enactment. So I think that was there. I wasn't sure what the pass-through date meant.
So the underlying language, for example, allows the sale of baby food that's in inventory as of the time of the effectiveness. There's no corresponding language for
Formula.
formula. And there's also the issue of, it's not like these can be set up for Vermont overnight.
Oh, no, we got that.
So
No,
it is not.
understood.
It's just so long there.
Yeah,
Well,
well,
it's going to take some time to put filters on your water. That's the problem. And you don't want to end up with starving babies because there is.
well, the Attorney General will be reporting about any,
Yeah, but I'm not sure how the Attorney General knows if there's a shortage of baby formula.
me either.
This is the language that's being referred to, lines 8 through 10. That the provisions of this subsection shall not restrict the continued sale of inventory and stock before January 1, 2027. So this takes effect, so this allows for baby food to, the continued sale of baby food that was in stock before January 1, 2027. So arguably, the infant formula would take effect at a later date. And so there wouldn't be language, assuming that's at a later date, there wouldn't be language in the bill that said, you can use your old stock.
6 months. This is a 6-month, provision, right? Can we add that in?
Well, not really. So the bill takes effect, the section 1 takes effect July 1, 2027. So this is saying anything that you had in stock before the passage could be used. So
It's a year.
Who has in stock? The manufacturer's warehouse or the local grocery store?
Local retail.
Retail, okay.
So the question is, what's the timing that we put in for once the provision is passed? So what's the timing here?
Rather than pass, just say the effective date.
The effective
Goes into effect.
Yeah, so the effective date for this is July 1.
nope, it's January 1, 2027. So that's when this takes effect. And this is saying if you had baby food in stock, you can continue to sell it after that date.
The problem is formula.
And that's what they're saying.
That's what we're trying to put in place. What's the timing for formula?
So there isn't, it would just be when it takes effect, that there isn't a ability to sell back supply.
Okay, so right now, if this bill passes, what's the timing for baby food?
For baby food, so all of the provisions take effect January 1, 2027. If a retailer has a supply of baby food prior to that date in stock, they could continue to sell it after that date.
So what statement can we make that allows for the sale of the baby formula once this is enacted?
I think you want to do something in the contingency that that sort of says the same thing, except that infant formula in stock, I don't know what you want to say, 6 months prior to that date can continue to be sold after this section takes effect.
Or baby formula in stock prior to that date?
Infant formula.
Infant formula.
So I had.
Prior to that date, why put a time on it?
Well, that's a policy choice, whatever, 3 months, 2 months, you choose.
I would just say in stock, because there's no way to predict whether it's how are you gonna know it's 6 months?
Okay,
I've got 6 minutes.
Yeah, can't.
okay. Make that change.
That would be helpful.
Nervous about the formula.
I'm not.
So this is a favorable with amendment.
It sounds like you might not be voting right now.
I think you're right. I think I'd like to see the language before we vote on this.
Okay.
Yeah, and then we can vote on it. We can do that tomorrow.
And can we do? I mean, our baby formula is not going in for a year, our baby food. Can we do not enacted, but goes into effect for formula? Because California might say, and it's gonna go into effect in 2 years. And then we've got Vermont hanging out there, so it's not just the legislature votes. But there has to be, and an act goes into effect.
Right.
Too early.
Leaving that in Katie's hands. Quick question,
That's
because
a
we're
policy
on the
choice.
floor.
Is this testimony that we just got, has it been presented to us before? Because it's frustrating getting this at the 11th hour.
Well, Bill Driscoll was in last week.
Saying these exact same things?
Very similar. Yeah, no, it's not last minute. The last minute was the person we invited in from the manufacturer. It's okay. And I think we did hear this. So, but I'm not convinced that we shouldn't do something. So the policy question you're asking is,
do you want the infant formula piece to take effect on enactment in another state or on effect in another state?
I think on effect,
On effect.
I think Senator Cummings was comments.
Okay, I will make that change.
And can you get me that? Copy that?
Yes.
When we did seeds, we did 6 months.
No, we're being
Yeah.
called to the floor. So Bill, I know you want to say something.
Yes.
I hear you.
We're- Just the FDA approval is gonna have to be accommodated. So
Yeah, there's all of that. And that all has to happen. That's a
Yeah,
legal
it's
requirement.
ongoing, it's
So regardless of what it says in the bill,
Well,
it's
you
a
don't,
legal requirement that has to be gone through.
you
right,
don't want to
just
do
want to avoid
a
it.
marker.
No,
Yeah.
if they violate it, you can sue them, yeah.